Hello, everybody, and welcome to this episode of Mastering Midlife, How to Thrive When the World Asks the Most of You. I am your host, Mark Silverman. Today, I'm joined by a really good friend, Catherine Reese, Kate Reese, to me and now to you. She is a family law attorney with Reese Law in Northern Virginia. The accolades go on for pages of best lawyer, super lawyer of U.S. News and World Report in Northern Virginia Magazine and Washingtonian. It goes all the way back to 2009. I couldn't even list all the accolades for Kate and her company. She's also just received a master's in counseling.
Yes.
Because she's moving her business more towards mediation and being able to do different kinds of help for people who are in the process of getting divorced or thinking about getting divorced. Besides being a lawyer and having numerous degrees, she's an avid scuba diver. She does yoga. She does Krav Maga, so she can kick your ass. She's amazing. She travels all over the world. And I am really glad to call you friend. Kate, thanks for being here.
Thank you.
So, Kate, the reason I want to talk is a lot of the people that we talk to who are in the car listening to us now are either pondering getting a divorce, getting separated, having troubles in their marriage. I hate to say it, but the demographic is just rampant with it. And you and I have had so many conversations about this, and your take on how to do this with love and to keep the children in mind and keep people intact has really been inspiring to me. So I wanted to ask you to talk to the audience about this process.
Okay. Back in the day, there was just simply the courts. But before the courts, there was the community and the church that would help when a family was in trouble. Courts are not really a great fit for self-determination. You're basically handing your life over to somebody in a black robe who's going to know as much about you as they can read in your file, and they hear on a trial day that's no more than 6 hours for however many days you may have it. In family law, we have wonderful, wonderful assets now in the way of collaborative law and in mediation, so that trial is not the only choice that you have. So one of the first things that I discuss with clients after they tell me a bit about their fact set is process. Would you like self-determination? Would you like to decide how your family is going to be restructured? Do you have a relationship with your spouse where it would be fruitful? There's openness, there's no deceit going on, there's some trust that's still there, so that the children and the parents can create this new family structure where both parents are actively involved, both children, or however many children there are, know where they're going to be, when they're going to be there, and that they have the love and support of both parents. Sometimes cases don't go into the collaborative process because both people have to agree, but regardless of how a case comes in, whether it's a very hot, looks like it has to go to court matter, or something fairly simple that turns out to be more so, mediation can often be used. And that's also self-determination. That's, if I'm in the attorney position, I'm your advocate, and I'm educating you, and I'm discussing options with you, and I'm with you throughout the process. If I am the mediator, then I'm the neutral. I can educate on the law. I can make sure everybody has thought through their choices. We work on planning things out when it comes to children's schedule. A common issue that pops up is that both parents might agree that a child will participate in an activity, but where? In mom's neighborhood or dad's neighborhood? And what happens if the other parent doesn't want to support? Well, usually that means that the child isn't a good team member and may not get to be in the games. So we can take away a lot of the animosity by using alternative dispute resolution in the form of collaborative law and mediation. Again, even if a case has already been filed, to bring the temperature back down and get these two people to focus on the best interests of the children and what actually needs to get done for their children to have a good childhood. And please, let's let them complete it. They are not adults, and they should not be your best friend. They are your child. And so we work through all the options. And sometimes the option is litigation, in which case we have the reputation for that, and we are prepared to go if that's what we need to do. And our success rate is very good. Very good. I won't brag.
So, you know, I've recommended my clients to you and people that I know because I trust you. One of the things that people think of when they think about divorce attorneys is sharks.
Yes.
Like we're gonna take two pit bulls and we're gonna have them fight things out for us, and that usually turns out to really rip the families apart. And one of the things I love about you is one of the reasons you fight so hard in what you do is because you care about the well-being of the children.
Yes.
Like
Yes.
that you put that first.
And I try to get the parents to put it first, because the bottom line is that if you have to go into court and you have to say every rotten thing the other parent did to make sure the judge understands why what you're asking for is reasonable, that bell does not get unrung. The statistics show us that if you go to court once, you're probably going to be going multiple times. When the modification comes up for child support, when the modification of custody comes up because the child is no longer 3, they are 13. So it's a bad cycle to get in, because it does bring with it animosity. And the animosity is actually, I would say, what's almost required by the court system because of what we have to present in the course of a case.
What does that mean?
Well, I don't want to make somebody's drug use a public record. I don't want to impact somebody else's job. But if there is consumption of substances while they have the child and the child gets hurt, I need the court to know the whole story. And that happens in open court. We are not.
So that makes it part of public record.
Yes. We do not operate in the ways of old England with star chambers. These courtrooms are public. And even if you get a protective order or another order to seal the record, that just means that there's 4 people that can get in that record. But if one of those people wants to make it wallpaper somewhere, you can't stop that. So privacy is something you get in mediation and collaborative that you do not get in a court setting. And there's some, bad behavior that's got to be brought up. If children's lives are threatened or endangered, whether emotionally, mentally, or physically, we will find every piece of evidence that can be found on that, and we will present an argument to the court to protect that child.
So someone walks into your office for the first time.
Mm-hmm.
They've just found your name. You were referred to them.
Mm-hmm.
They sit in their office. They don't know what they're in for.
Mm-hmm.
What are the questions that you ask them that you would like them to ponder for themselves?
Well, I usually ask them for a bit of history, and then based on what they tell me, for example, somebody might come in and say, I absolutely want my children 100% of the time. So I explain nobody's rights are going to be terminated unless I hear something really significant. And then I ask them about why. And what I often hear is that there is not a lot of respect for the other parent, and not and some venom. They're hurt. They feel hurt. But when I ask, well, who makes breakfast? Who makes lunch? Who gets the child a pediatrician? If you're both in the same room and there's a boo-boo, who does the child go to? Who makes dinner? Who does bedtime? Who does reading? Who does bike riding? And sometimes, not infrequently, I will find that the other parent is a pretty involved parent. So you'd be altering your children's lives to make them essentially lose a parent. And one thing that I tell many clients is, I don't think a child should lose a parent because the parents have decided to get divorced. I think it can be done, but the children need to not be in the middle of the litigation. And that means that the parents need to be adults and not talk about it. Your children are not little decision makers. They are not arbiters of what's going on. They need to be able to have their childhood. It's our job to protect that childhood.
Your passion for that is so palpable. I'm really grateful that my divorce, my ex and I both made a really strong commitment that our relationship was to stay intact for the kids.
Yes.
And it really has healed us both tremendously. We've both grown tremendously because of it. So let's say someone comes into your office and you figure out that the person that they're divorcing is actually unreasonable, is kind of a not a great parent, not a great spouse. The divorce is absolutely warranted, and they're not going to be cooperative. Now what questions do you ask?
Okay, if I'm told about that person, I'm pretty much telling the client straight up, you're telling me that collaborative won't work because you don't trust them to sit down and be honest or to play ball, and mediation will not work at this stage. So we would look at filing litigation, whatever we can file. We do have state statutes we have to deal with. So if you are leaving on a fault basis, you can file right now. If you're leaving because you're sick of it, you need to wait 1 full year if you have minor children, or no property settlement agreement if you're without children. So we have to talk about the litigation, and the litigation is not going to be pretty, and we can't really make it too soft. The law doesn't allow for that. We have to say what we have to say.
So once you decide you're not doing collaborative law and you're going to court, it's inherent in the system that it's not going to be fun.
Correct. However, at any time we can stay the case and go into collaborative. We can also, in the 8 to 18 months it takes to get into trial, we can continue to work on that case. We can do a property custody support settlement agreement. We can send that to the other side. If they don't want to comment, then again, we're stuck with litigation because they're being unresponsive. But it does happen that the mediations happen. I mean, frankly, I've got a lot of adorable nicknames. They start with A, B, and C. B's got Barracuda in it. The others I probably shouldn't mention. But it's a bit of a badge of honor because they usually come from the opposing party who I just took apart on the stand. It is not fun to be cross-examined. But if that's what needs to happen, and once we get closer to trial date, everybody starts to understand the reality of this more and more so, and that you are turning everything over to a judge. And that judge may or may not think like you. The Fairfax bench itself will say 15 judges, 45 personalities. They freely admit this. They do. And so, some days when you see that look, you have to say, okay, I'm going to just figure his dog got hit by a car this morning. Let's proceed. And then you do. You might be faced with biases that you have no control over. In mediation, if I'm representing the client, we pick our mediator. The court doesn't pick our mediator, we pick our mediator. So we know who's good if we've got this fact set and we represent this party. And everybody else who's experienced in family law in this area, which is specifically family law, is not a large group. We all know the same people. And we know what their biases are. So don't send me an email saying, let's use X, when he's got a huge male bias and I know it and I represent the woman. Don't bother. But so we work through it and try to get what we can. And we do try to get agreements before court as well, which are called stipulations. Trials do settle at the 11th hour, and it is so annoying. Everybody has spent the money now. I'm not hyped up. I don't need to go to trial. I've only had 2 trials in the last 18 months, which makes people shocked because of my reputation as a litigator. But my God, I have settled some of the hardest things that you could imagine settling. On custody, on money, when somebody's near to die, when there's serious mental health issues in play, when there's children with suicidal ideation. These are still resolvable. They're still resolvable, and you can get more in an out-of-court settlement like collaborative law or mediation would allow for, or just negotiations between the attorneys, than you can get in court. So you can have a tie-breaking authority in a property settlement agreement. You can have college costs in a property settlement agreement. You can have extracurricular costs in a property settlement agreement. You can't get those from the court. They can't give them to you. They don't have the statutory authority to do it. So I think mediation and collaborative just have everything going for them. And there are some cases that just won't. And if so, okay, we'll go. We'll go and we'll do it and we'll kick butt and we'll get, the best possible result.
Yeah. Given what I do for a living, I talk to a lot of people who are in relationship turmoil. And I have seen over and over the years, people cutting off their own nose to spite their face, spending all the money that they're going to need to live on because of hurt, because of fear, because of misinformation from other lawyers, from all that stuff. And I just watch people destroy their own lives, their children's lives, and then their financial well-being when they're trying to get money from people just because of the irrationality of hurt. How do you deal when you start to see the irrationality show up? What do you do with that?
Okay. Well, if that's the person who walks into my office as a client, I will, without hesitation, tell a client that they need to get with a therapist if they don't have one, and I will give them names if they don't have that information. But considering the hourly rates of attorneys and those of therapists and the specialization of both, money would be well spent with meeting with a therapist and using that resource. And sometimes I have to give them a little extra push in that, that person might be a good expert for you at trial. I don't know yet, but I think you need this support. In collaborative, we have a built-in support system, and that is that we use coaches, and those are mental health trained professionals. So they meet with the clients before the collaborative meeting with the attorneys and the other party, because we're all in the same room, and help them process the emotional aspect. For example, today we're talking about the house. We know that the wife is sensitive about the house. That is home base for her. That's where she raised her children. Husband's less attached. If you want to use a flamethrower in a different setting, you'd say, let's sell the house. You do that in a collaborative meeting and you are not acting consistent to the practice. So we don't do flamethrowers.
So what would be consistent to the practice in that? Instead of selling the house, what would be the conversation?
The conversation would be that we have these 3 or 4 high dollar assets that are holding up cash, that are non-liquid. And while you'd like to keep the house, you'd also like $20,000 a month in support. Here's what the math looks like. And we do use financial neutrals. So you don't have to hear it from Kate. You don't have to hear it from Kate's client. You're talking to a financial neutral. We've specifically selected for the case, the attorneys together, and that person will help with that. So it's usually there's blue chips and there's red chips. There's current money and there's future money, like retirement is future money. And sometimes you can make a deal out of just one type of chip. I keep the business, you keep the house. Yes, you should see what the value of the business is. Yes, I should know what the value of the house is. Yes, maybe a differential should be paid. But what's killing that person going into any of these processes when they have asked for or learned that their spouse wants a divorce is the pure fear block. That block can be so strong that information cannot get in. So with collaborative, we have a lot of processing time. With mediation, we process before, during, and after. And I think maybe twice in 21 years we didn't reach agreement in mediation. So it's pretty rare. We will do what it takes to get to the right settlement. We do not settle for whatever. We will settle for what is satisfying to the client and is reasonably workable. So it all depends on the process and how we might use it. But if you can get the emotional attachment away from the money, that can help. And that is one of the things that the counselors, as far as mental health professionals and serving as the term coaches, are able to help with pre and post meeting. You may not want to be in that room with that man and talking about money because he knows more than you do and you're not feeling secure about it. You'll be talking with the coach before the meeting. So.
Wow. And so far, I love the way you've been weaving between courts and law and mediation and just giving people like the options that are always in front of them is really cool. Something I learned from you that I didn't realize was that you would go to a family law attorney to renegotiate an agreement that you had. So you got divorced and it's no longer workable financially or for whatever reason, or you want to revisit the kids, the custody and all that. What do people generally come in for that?
Yeah, somebody has to move. It's pretty common, really. As a family law attorney, our cases are probably no more than 40% divorce. There's a lot of post-decree work, and you could have gone through any process, but those children get older, incomes change, somebody wants to or has to move. So it's the same fact set, in which case I want to know all about how the relationship's been with the other side so far. How has it worked? I want to know what they think the problems are. I want to know if they think the person would engage in collaborative. If the relationship is good, I'm going to push that. I really am, because it is the one that protects the family unit, be it in two households or one, the best, because there's no game playing, no hiding. Mediation does not have the same rules as collaborative. Collaborative has very specific rules. So that's sort of what we work through, and what do you want to keep about that? Because I tell them, if we do a litigation, certain things are going to come up. The DUI is going to come up. Yes, I understand they have high security clearance, but things are going to come up. There's, been inappropriate behavior on one level or the other. Most, if it has to do with substances and kids are involved, that's highly concerning, because those things can be so dangerous. So it depends on what they tell me. If they tell me they've always been unreasonable, there's no way in hell, then I say, okay, then maybe we need to get a motion filed. Not that we wouldn't go back to the other processes, or we can have a time constraint. Right now, there's a circumstance where somebody needs the other side to sign off on a passport. She has orders. She needs to be in Italy. He doesn't want to do that. We have to go get a protective order because we don't have months to work this out. So, but a litigation is a really good thing as far as a kick in the pants to the other side. If you've been saying, I'm really not happy, I really don't want this isn't going well, why don't I know what's going on in the money, and you're really not getting any response. When you file a litigation, you have put them on notice that you are serious. There's nothing more serious than that. And that can often bring people to the table.
That's a good segue to, so let's wrap up with just your passion for mediation. You went back to school again,
Yes.
and you got your master's in counseling.
Yes.
Which is just a breathtaking thing to watch. You learn these skills and bring them to your practice.
Mm-hmm.
Tell me what your passion about mediation is. It was peppered through the whole conversation, but now I want you to kind of be pointed.
Well, let me just say how the master's came about. I was in a custody case. I represented the father. The mother was unreasonable. The children were 11 and 13. They were convinced that their father didn't love them. He was not the one who did the convincing on that. And we got the child who was the older child who had, again, suicidal ideations, stayed in a room all the time, read Ender's Game and other sort of fantasies. And her life was just getting darker and darker. And we got her with the right therapist. And that right therapist, which is my job to know who should fit which case. And I will make a list. I will go email them myself. But she found a way to get to that child that wouldn't talk and wouldn't socialize. She said, fine, what chapter are you on? I'll start there. How many can you get through before next week? And within 6 weeks, this child was incredibly, visibly better off. Her skin wasn't gray. There was some pink to it. She was eating food. She was willing to sit at the dining room table. And they're still working together, but she did amazing work. And it was a perfect example of how the court couldn't fix this. The court could say the father's going to have the child these days, the mother's going to have the child these days. But where was the help for the child? And if they were going to fight about who it was, well, the attorneys got involved. We picked her, and she was great. So and I've told her since, that's why I decided to go, because to help people reach agreements, you need to understand them. And so I can see a lot more now in working with people. And this is in every consult I have. This is in every communication that I make now. It is not the same for me as it was before I started this program or completed it. But it is good, because as a human being, we should be empathetic. As an attorney, we're told not to really let that out there. Yes, your client should know that. Yes, your client should know that you empathize, you understand, and it's their family. It might be our case, but it's their family.
No. So now you just got a glimpse of why I love Kate so much, and I wanted her to be on the podcast to talk to you. That was such a moving story, and I know your heart, and I've watched you through this process, and you have learned so much, and I see you bringing it into your practice. So if you want to get in touch with Kate and her practice. It's Reese Law with Rease, which I've known her for years, and I just figured out
Reese.
Reese. Me and spelling, man. But we will put that in the show notes, and it'll be a direct link so you can get right to Kate and her practice. Thank you so much for spending time with us and sharing so heartfelt. It's such a hard and academic conversation.
It's hard work, but there's nothing more rewarding than having the end result of a client who is happy and the children are good and the other side is actually happy too. They're going to be able to co-parent. They're going to be able to make decisions about their children. And when you come in and your kids are 3 and 4, you got 17 years and 16 years left. Do you want it to be happy? Do you want your children to be happy?
I'm great. I'm grateful to my ex, Robin. She's going to be on the podcast also. We are going to talk about having a loving divorce and how over the last 10 years we have been friends and raised our kids together and the healing that has occurred. So I can't wait to share that with you. Again, Kate, thanks for being with us.
Thank you.
To everybody else, thank you for your precious time and attention. I love you and have a great rest of the day.